Some of the names have been changed in this video to protect the identity of weak-minded individuals that are scared of taking responsibility for their own actions.
Right, well, hey guys, part 3 of Dr. Incompetent. I've heard nothing more back from the Health and Disability Commissioner. Not that I expect to right now. It takes time for these things, for the wheels to turn, so to speak. But I'm guessing that the Health and Disability Commissioner has passed the complaint on to Dr. Incompetent, and now he's retaliated, from at least what I can see anyway. He's hired someone we'll just call J. Pink. Now his last name may be a colour in the spectrum, it may not, but we'll just call him Mr. Pink. Mr. Pink writes me a letter, or at least he writes a person called M. Keen, or Mr. Keen, a letter. And this letter was derived via an envelope, handwritten address and name, by hand written up the corner, and he had some courier, I'd call him a trespasser, because he walked straight past, no trespassing signs, show up at our private property at 8 o'clock at night to deliver threats. I'm going to take it as a threat, because I've asked them if it was supposed to be some sort of vague threat, and they've not responded. And as far as I'm aware, silence is acquiescence, or passive acquiescence, and therefore you're going to do nasty things like that, and you know, you've caused us alarm and distress by getting this sort of stuff, and by golly, you better clear up any confusions or points of clarification that may be needed. But I'll digress. I'll read out the letter first off. This is now, names in this letter will be changed to protect the identity of the cowards that can't take ownership for their own actions. Okay, so it says, "Dear Mr. Keen," we'll keep that one, the actual name. "Dear Mr. Keen, 1. I refer to your video you made on YouTube, which is entitled Health Disability Commissioner Complaint relating to Dr. Incompetent Part 2. And yes, the name has been changed to protect the identity of those sorts of individuals. Number 2, in the video you post, you also read out the text of your letter emailed to the Medical Council of New Zealand and seriously impugn Mr. Oh, changed from Doctor now, but we'll carry on. Mr. Incompetent, in your references to him sufficient to cause him injury. As far as I'm aware, the injury here was the fact that my wife's leg swelled up 3 times the size it should have been, because Dr. Incompetent told her not to wear a brace and just to fully exercise it. A freshly broken bone, straight after radiology and x-rays had confirmed this. And to let it heal naturally, natural course of action, or take its natural course, and let 14 mils more bone grow and weaken the whole ACL. But I'm not a doctor, what do I know? To me, I just use logic and sound reasoning. Anyway, tally-ho, let's move on. 3. Although you have sent the text of your letter / email to the Medical Council, who hold it confidential, have now published it by putting it on YouTube. Accordingly, the video post, in brackets, including reading out the letter / email, close brackets, is defamatory. 5. I have been instructed by Mr. Incompetent to request you cease this defamation by taking the video post down, close brackets, including reading out the letter / email, close brackets. Let's just point out here that whenever you see the word including, and especially in those little brackets there and all that jazz, it means including is an exclusionary term, which means he's only talking about the reading out of the letter/email. He's not referring to anything else whatsoever, just that. Okay? Because legally, including is an exclusionary term. Anyway, number 5. I have been instructed by Mr. Incompetent to request you cease this defamation by taking the video post down, including the reading out of letter/email within 24 hours of receiving this letter, and to desist from taking the defamation up again at a later date. What defamation? Don't get what you're talking about. I merely, do whatever I wish, and you really need to define these words you're using. Anyway, Mr. Pink continues. If the video post, in brackets, including reading out the letter/email, close brackets, is not taken down, Mr. Incompetent will be considering and taking additional legal options he has. Yours faithfully, Mr. Pink. We'll just call it that. Honestly. Okay, so I replied to Mr. Pink with the following. 18th of July 2007. Greetings. His given name. We thank you for your correspondence, which we received via a trespasser upon our property in the dark, just before 8 p.m. this evening at your request. The trespasser failed to identify who he was looking for or supply identification. The trespasser proceeded to hand us an envelope stating we may have won the lottery. Hysterical. At least, should the trespasser have met our guard dog, it would have been for us. In our opinion, this was stupid and unnecessary action to be taken. Please relay to this trespasser to not attempt such an imbecilic action again. Although a family member was with this trespasser, she would not have been able to control such a security patrolling. Note: no trespassing signs are posted, which were ignored. Notice: any implied right of access you presume to have with regards to access to address you attended is removed. Any further trespass upon our property shall be considered aggravated trespass, and appropriate actions will be taken in the future. Please clarify without delay the following 34 points of clarification, point by point. 1. In this correspondence addressing Mr. Keane, you allege Mr. Keane had posted a video you allege Mr. Keane had made. What evidence do you have to support this? 2. You refer to a YouTube video, Health Disability Commissioner complaint relating to Dr. Incompetent, Part 2. Would you be referring to www.youtube.com? 3. To our knowledge, no such video exists with this title, at least on www.youtube.com. Please clarify. 4. You then allege Mr. Keane read out the text of your letter/email to the Medical Council of New Zealand and seriously impugn Mr. Incompetent in Mr. Keane's references to sufficiently cause him injury. We do not understand this. Can you clarify or explain further? 5. Define impugn. Number 6. By impugn, are you referring to seeking, receiving and imparting information and opinions of any kind in any form? 7. Define injury. 8. Or are you referring to injury that Mrs. Brunette suffered unnecessarily, alarm, pain and distress from while Dr. Incompetent allowed 14 days to drag on while under his care. 9. You then allege you, which we presume is referring still to Mr. Keane, sent the text of your letter/email to the Medical Council, who will hold it confidential. You have now published it by putting it on YouTube. Do you represent the Medical Council? It appears that you are speaking for them. Is this correct? Do you have any evidence or witness, first hand or otherwise, that Mr. Keane published what you allege? 12. You allege, accordingly, the video post, including reading out the letter/email, is defamatory. Define infamatory. 13. What is your allegation according to? 14. We can appreciate you have instructions to make a request of Mr. Keane by Mr. Incompetent. Are you referring to Dr. Incompetent? 15. As to your request to cease this alleged defamation, we would be happy to grant this request should you be able to sufficiently explain your allegations to our satisfaction and provide evidence of your allegations. Are you aware of any existing? A removal fee may be applicable for your request to be granted and processed. 16. Furthermore, it would appear you have required a time frame of within 24 hours upon receipt of this letter. Is there an obligation for compliance to your time frame that we are unaware of? 17. Also requested is to desist from taking the defamation up again at a later date. As we do not understand what you are referring to by defamation, please clarify. Is there an agreement between Mr. Keane and Mr. or Dr. Incompetent to comply with such a request? Is there an agreement between Mr. Keane and or Dr. or Mr. Incompetent we are unaware of? Lastly, you state, if the video post, including reading out the letter email, is not taken down, Mr. Incompetent will be considering and taking the additional legal options he has. 19. We presume you are again referring to Dr. Incompetent and not Mr. Incompetent. Please clarify. 20. Is Dr. or Mr. Incompetent considering additional legal options? 21. Or taking additional legal options? 22. Perhaps both. What may these legal options be? 24. Is there a request or an ultimatum? 25. Or more so, a vague threat? 26. Does this request exclude everything but reading out the letter/email you allege was sent to the Medical Council? 27. To our knowledge, everything stated within a similarly entitled video content is factually based, backed with video evidence and first-hand witnesses, along with opinions and information received and imparted according to rights and freedoms expressed and exercised within the New Zealand Bill of Rights Act 1990, Section 14. 28. How was Mr. Keane's address obtained by yourself and Dr. Incompetent? 29. To our knowledge, Dr. or Mr. Incompetent has not been supplied these details by Mr. Keane. Was this address obtained legally? 30. Did Mr. or Dr. Incompetent ascertain this by assessing Mrs. Brunette or Mr. Keen's medical records illegally. 31. Has a breach of the Privacy Act 1993 occurred in relation to Mr. Keen and or Mrs. personal details? 32. Do you, Dr. Incompetent or Mr. Incompetent, have any first-hand knowledge of any of your allegations? Well, do you? 33. Favourite number for those fucking Freemasons. What is the nature and cause of these allegations? Primary importance. Do you have subject matter jurisdiction? Believe it's up to the fucking prosecution or the plaintiff to supply beyond a reasonable doubt the burden of proof. Moving on. 34. Is this a retaliation for complaints being filed against Dr. Incompetent with the Medical Council? Dun 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 dun. Notice. This correspondence shall be copied and forwarded to the Medical Council for maximum transparency and to be included within the complaint filed. Notice, any correspondence of any kind between Mr. Keen and any other person shall be posted on multiple forums of any form for maximum accountability and transparency, consistent and in accordance with rights and freedoms expressed within the New Zealand Bill of Rights Act 1990 Section 14. A personal favourite. Notice. Failure to respond to this notice by 5 p.m. the 19th of July 2017 shall, in the absence of evidence to the contrary, be construed as contrary to your earlier allegations stated within the enclosed letter dated the 17th of July 2017 addressed to Mr. Keen. You may contact Mark on and cell phone number supplied or via email address supplied also to clarify. Notice, a video similarly entitled has been temporarily reclassified as private until 5 o'clock p.m. 19th of July 2017. In the interim, as a courtesy free of charge, you're fucking welcome. All rights reserved, without prejudice. Me, myself and I, and the horse I rode home. And so, after which, I received a couple of dead phone calls over the 19th. I don't know who they were. They caller unknowns, you know, confidential numbers. So, don't know who they could have been. I'm not gonna. I think someone listened to me say hello about 3 times and then hung up. But then it could have been Windows technical support. Or it could have been an insurance salesman. Who the fuck would know? Although what I do know is that according to this little bit here, and let me just read it again. Notice failure to respond to this notice by 5 p.m. 19th of July 2017 shall, in the absence of evidence to the contrary, be construed as contrary to your earlier allegations stated within the enclosed letter dated 17th of July 2017 addressed to Mr. Keen. In other words, if you don't reply to me by the 19th of July, 5 o'clock, you're full of shit. You've got no evidence to back your allegations, and silence is acquiescence. And as nobody called Mr. Pink or any other colour in the spectrum rang me, I'm just going to take that as thank you very much. Consider a default notice to be sent out to you soon, Mr. Pink or Purple or whatever. Yeah, and I would suggest, especially considering you're mentioned in part 3, to, if you're going to send nasty letters by hand delivery late at night, which I might add scared the living shit out of my 10-year-old boy, then, you know, you might want to get your facts straight. You might want to have evidence, and I'm sure Dr. Incompetent's probably paying you a pretty penny for your services. Probably get better legal advice from someone who's studied something on YouTube for 3 or 4 years or 4 or 5 years. Perhaps someone who studied legislature and rules of society and the legalese and doublespeak and tricks of the trade that every barrister, lawyer or solicitor that's first duty of course is to the court because they're a member of the Bar Association and the Law Society, that, you know, that might want to get someone that understands all that shit. Anyway, bye. See ya, Pinky.
You are.
Good luck.